Welcome to Rocinio Law. Here's your host, Albert Rocinio.
Today, we're going to talk to you, just generally speaking, about some estate and trust issues. People come into my office all the time. I've been doing estate and trust work for years, almost 30 years. And people come in and I want a trust. I need a trust. And I was told this about a trust. And a trust will save money. A trust will make things easier. A trust will protect all my assets. My buddy's friend's cousin did a trust, and the attorney did him a trust, and now I want a trust because they told me I should have a trust. You hear all these things, and usually what happens is it's all nonsense. It's not accurate. You only get part of the story. As I like to use as an example, I always, because I do also a lot of personal injury and workers' comp work, and I always get somebody that says, oh, my friend's sister's cousin's brother got $1 million because they broke a pinky in an accident. Well, I broke 2 fingers and I want $1 million, or I want $2 million. And invariably, what they're saying is nonsense. It didn't happen that way. That's the story they got. But what they don't know is that the person that supposedly got $1 million for a broken pinky had 3 major spinal fusion surgeries. And are messed up for life. And yeah, they also had a broken pinky or broken finger, but they didn't get the $1 million for the broken finger. They got the $1 million for the 3 spinal fusions that they had to go through, and the fact that they can no longer walk properly or play golf or do whatever it was they used to do. So you have to take this stuff when you hear it with a grain of salt. There's a lot of talking heads out there, and I think you know what I mean by that. Telling people stuff that is either way too generic or just simply isn't accurate. My thing that I always run through people with is I ask them about their assets. I talk to them about their age, what's going on with their family. Do they have young kids? Do they have old kids? What are their goals? And you have to go through all these things. These are proper estate planning and trust planning questions. People don't understand that when you put your money into a trust, you want the trust, you're putting it in for a reason. It could be Medicaid planning. It could be estate planning. Maybe you're protecting it from creditors. Or you're protecting it from things like divorce or kids' divorces in the future if they should happen. All valid. But those trusts have to be qualifying. As an example that I use is if you have some money and it's in your savings account and it's your money, and you have access to it and it's there for your benefit and you can spend it on yourself whenever you want, then you take that money and you put it into a trust. And you're the trustee, so you control the money. And you're the beneficiary of the trust, so the money is there for your benefit, and you can use it anytime as you want. From a practical standpoint, what has changed from before you put the money into a trust? From a practical standpoint, absolutely nothing. It's still there for your benefit. You still control it. It still can be used for you. So the government comes in, let's say if it was for Medicaid purposes, and that money was available to you and accessible, and they're going to turn around and they're going to say, it doesn't qualify for Medicaid. It's still part of your Medicaid estate. If you were doing it for Medicaid planning, that's a bad thing because you went and you did something and you didn't do it right and you didn't follow all the rules and then you didn't get the benefit of why you did it in the first place. So you got to know what you're doing. Another thing that oftentimes we see is people don't understand the consequences of what they're doing. So let me give you an example between dying with a piece of property and letting it pass by way of your will, which even if you do a trust, everybody should have a will. Everybody should have a power of attorney, which handles your financial affairs while you're incapacitated. And for those who want them, should have a living will, which the way we do it here in my office, you have an advance directive for healthcare where you're telling the world this is what I want to do. In the event I'm sick and can't speak for myself, an adorable healthcare power of attorney where you're designating somebody to speak on your behalf when you can no longer speak for yourself. Probably 90% of my clients have those today. Most want them, but again, it's a personal decision. But understand that there's a difference when you put something into a trust versus when you die with it in your name. So let's say you have a house, and the house is today worth $1 million. And you've put that house into a trust. And the basis of the house is $200,000. Okay? So you die, and the trust now sells the property for $1 million. and you transferred the property maybe in 5 years ago, whenever the fact is, doesn't really make a difference for this example. So you sell the property for $1 million because that's what its fair market value is today when you died, and the trustee sells it, to be more specific. And what happens? Are you going to pay tax? Yeah, you're going to pay a tax. You had $1 million sale price. You had a $200,000 basis. The difference is $800,000. That's the profit. When you transfer property into a trust, you get what's called a carryover basis. The basis that you have, the $200,000 in this example, is the same basis that the trust now has in the property. So selling it for $1 million leaves an $800,000 profit. If just say, capital gains tax is 20%, that's $160,000, 20% times $800,000. It's $160,000 in taxes, capital gains taxes. Okay. Now, if that property was in your name when you died, and it passed via your will, and your executor sells it, and your executor sells it for $1 million, because that's the value, and you had a $200,000 basis in the house from when you bought it, what's the tax? Is it $160,000, the same as the trust, because you had $800,000 in profit, 20% capital gains tax, it's $160,000? No. Why? Because when you die and the property's in your name, your estate and or the beneficiaries get what's called a step up in basis. What does that mean? That means that when you die, the property had a value of, or a basis of $200,000, but the fair market value was $100,000. The beneficiaries in the estate got a step up in basis to $1 million. Okay? Now they sold the property for $1 million. So if you have $1 million sale price and $1 million basis, what's your profit? Your profit is zero, right? You have no profit. No profit means no tax. So the trust just cost you $160,000 in taxes, where the sale of that property, while it's in your name, is tax-free under that scenario. You have to understand that. Most people come in, they don't understand that, okay? And transferring highly appreciated properties into a trust can trigger a large tax bill, one that you don't understand and you didn't anticipate, okay? So sometimes the way around that is transferring appreciated assets which are not highly appreciated. So you had $1 million house, it has $1 million basis, you transferred it in. If the property then you died and the property sold for $1.1 million, you've only got a profit of $100,000, and in our scenario, 20% capital gains, you've only got tax of $20,000. Big difference, right? Another way to use trusts is if you have large insurance policies. Insurance policies which are owned by you are includable in your estate. So you have a $5 million insurance policy, even though your wife is the beneficiary, but it's your policy, you own it, and you're the insured, you die, that $5 million policy is included in your estate to determine tax purposes. Take that policy, transfer it into a life insurance trust, which is now the owner of the policy, because you're no longer the owner, you transfer the owner in. You're still the insured, because it's still based upon your life, and you transfer the beneficiary from your wife to the trust. When you die, it's not included in your estate, so it doesn't affect your taxes. It funds the trust. There is no tax on the life insurance. And then it can distribute the money to your wife, or you can have your wife as the income beneficiary, saving the principal for your children, but with the principal being available for the health, education, and welfare of the beneficiary. So if your wife did need something, she could always have the trustee disperse the money. And that is a very important technique for the use of a trust with life insurance. And it works great. If you fit into that scenario, that's something that you should think about. It's a great vehicle. But again, everything is dependent upon your facts and circumstances. And really, you need to talk with an experienced estate planning attorney that have experience in Medicaid planning, in the use of these trusts, to understand what will actually work best for you, okay? General practitioners, and I do a lot of different stuff, but general practitioners don't necessarily know this. Your uncle doesn't necessarily know this. Your brother's best friend doesn't necessarily know this stuff unless they're an experienced estate attorney. So please be careful with that, okay? Because as I like to tell people, there's no free lunch. There's a pro and a con for everything, okay? You got to give something to get something, okay? It's not all get. It's not all pros. It's not all benefit. You know, you may, and it's deciding what are the best odds for you. You may decide to take that piece of property that's highly appreciated and move it into the trust, subjecting it to the potential of the tax in order to protect it from a Medicaid lien, which Medicaid lien could cost hundreds of thousands of dollars. Okay? And if it works out that way, then your gamble and paying, say, in our scenario, the $160,000 in taxes for capital gains worked out. But you never know what the future is going to hold. The best laid plans of mice and men, right? They don't always play out the way we expected. So you could make that move and end up having to pay that $160,000 tax, and maybe it didn't affect your Medicaid at all because maybe you never got to Medicaid. Or maybe you got to Medicaid and were on Medicaid for a few months, but then died. But those are the risks that we take when we make any of these decisions. So please talk to your local attorneys. Take the time to figure out what is actually right for you. You and I don't wear the same size pants. We don't wear the same suit. We don't wear the same bathing suits. My estate plan and your estate plan, and whether I need a trust and whether you need a trust, are not going to be the same. Just because I have a trust or I have a trust for my client over here doesn't mean that the trust is right for you. Or maybe a trust is good for you, but maybe it's a different type of trust. Maybe it's different assets that go into that trust. Okay? Don't paint with a broad brush. Know the specifics. Take the time. Get the professional help. Protect yourself. The whole idea is to try and put the odds in your favor to leave yourself and your beneficiaries in the best position possible. And always remember, and this is the other thing, that when you put stuff into trust, again, the more indicia of ownership and control and everything that you give up, the more likely it is to qualify for certain things like Medicaid, mean that you may have to take an asset, put it into the trust. You're not the trustee and you're not the beneficiary, or maybe you're a beneficiary, but it's a discretionary beneficiary at the discretion of the trust, and now you have to trust your trustees, whoever they may be, not being you, in order for it to be qualifying. Okay? And a lot of people, when they realize that, aren't comfortable with that decision. They didn't understand that. Okay? And like I said in the beginning, if you don't give up the indicia of ownership and control and benefit, what's changed? Nothing. And then what do you get out of it? Nothing. Okay? So please, keep it in mind. I hope you like this video. I hope you got something out of it. I hope it helps you direct yourself. You know, everybody should have a will, living will, if that's what you want. Definitely a power of attorney. If you need a trust, have a trust. You know, it's always better to plan and to have this stuff in place than to die what's called intestate, which means without documents, without a will. Because then you're subject to state laws and things may happen that you really didn't want to happen, and we see that all the time. But it's up to you to go to your local attorney, talk to a competent attorney that understands this estate planning stuff, and get the documents and the help that you need. If you do it, it'll work out. If you don't, then, well, you won't be around, but you may leave family members that are very upset because of things that are happening and the way they're happening and the additional cost and expense and time. You know, having all these documents, by the way, makes things a lot easier for your trustees, for your executors, or if you're doing a testamentary trust, which is a trust inside your will, which doesn't fund until after you die, which is great for a lot of things, especially for kids. They have different types of trusts, like a unified credit shelter trust. There's a marital deduction trust. There's all sorts of stuff that gets into some wicked estate planning if you have the money and it's worthwhile to spend to do that. Makes everything a lot easier for them and can make a big difference as to whether you pay tax and how much tax and where the money goes and how it goes and the cost in getting it there. All right, everybody, thank you. Please like my video, like my webpage. You know, give us some good clicks, give us some good reviews. Tell your friends about us. We look forward to seeing you again in another video at another time. Everybody, ciao. Thanks a lot.
Thank you for watching Rocinio Law. Please do not forget to like and subscribe.